are you able to see the screen?
Of course, yes.
Okay. Today we're looking at, we're going to look at part 3 of 4. Commercial law part 3 of 4. Let's just wait for about 5 minutes and see more people should join. Okay, so we can start. Can you hear me? Hello?
Hello, madam.
Hello?
Hello.
Okay, we can start. I think we can start. Are you able to see
Yes.
the screen?
Hello, ma'am.
Are you able to see the screen?
We can.
Yes.
Okay. So today we're going to look at part 3 of 4, commercial law. We'll start with the distinction between different types of business contracts. The distinction between different types of business contracts. So, business contracts are essential tools for formalizing agreements and ensuring that all parties understand their obligations. Business contracts are essential tools for formalizing agreements and ensuring that all parties understand their obligations. So I'm going to give you a detailed, hello, there's someone who's making noise at the background. Hello? So,
Madam.
yes, you can hear me?
Yes,
Yes,
but your
good.
voice is very faint. I'm not sure if it is our gadgets or what, but is it possible you can provide us with the meeting ID?
Okay, let me try to speak loud.
Before we continue, is there a way, ma'am, you can provide us with the meeting ID to join this from a desktop, maybe the volume will be better.
Okay, yes, you can join.
I'm failing
can
to use the link. It's requesting for the meeting ID if I'm on trying to join using a desktop.
If you tap the link, it's not, because you can join using.
When you're joining through the link, it's requesting for the meeting ID and the passcode. Like it's not automatic with the link. I think the volume will be better on a desktop because on the mobile, I can hardly hear you.
Okay, so this meeting is scheduled for everyone. So I'm sure everyone is able to join in. So I don't know the kind of problem you're facing. Hello? Okay, let us
I
proceed.
can hear you, ma'am.
So we're going to start by looking at sales contracts. So the purpose of the sales contract is to govern the sale of goods or services between parties. Let's look at its key elements. Description of goods or services, price, payment terms, delivery terms, and warranties. Let me give you an example. An example is a contract between a manufacturer and a retailer for the sale of a batch of products. Am I too fast? Before I proceed, am I too fast? Hello?
It's so
Are you
hard, ma'am, to hear you.
able to hear me?
We
You
can
are
hear
really
you.
so far.
Okay. So apart from sales contracts, we also have service contracts. So the purpose for the service contract, it outlines the terms for the provision of services. Let's look at its key elements. The scope of service, performance standards, payment terms, and duration. For example, an agreement between a company and a consultant to provide market service. Let us move to employment contracts. The purpose of employment contracts, it defines the relationship between an employer and an employee. Its key elements is job duties, salaries, benefits, work hours, and termination conditions. An example is a contract dealing the terms of employment for a new hire, including salary and job responsibilities. Under contract of employment, we have one, contract of service. Let's define a contract of service. A contract of service is an employment agreement wherein an individual agrees to work for an employer under specified conditions or specific conditions and in return for remuneration. It creates an employer and employee relationship characterized by control, subordination, and mutual obligations. So let's look at the characteristics of a contract of service. First is personal service. The employer or the employee performs work personally and cannot delegate tasks to others. Number two, control. The employer has control over how, when, and where the work is to be performed. Number three, mutual obligations. The employer agrees to pay wages while the employee agrees to perform work or duties. Okay. So we've talked about the contract of service. Now let's move to contract for services. Let's define contract for services. A contract for services is an agreement where the service provider agrees to deliver certain services or work to the client. The provider retains control over how the work is performed and is responsible for their own business expenses and taxes. A contract for service is an agreement where the service provider agrees delivering certain services or work to the client. The provider retains control over how the work is performed and is responsible for their own business expenses and taxes. Now, let's look at the characteristics of contract for services. Number one, independent contractor. The service provider operates as an independent entity, not as an employee of the client. Number two, control. The provider has autonomy over how the services are delivered. Number three, the provider is paid for the services rendered, usually based on an agreed fee or rate. So these are the characteristics of a contract for services. Now let's move to distinguish between employment and independent contractors, employees and independent contractors. The first one we'll look at is the legal rights and protections. Under employee rights, employees are entitled to a range of statutory rights and protections such as minimum wages, paid sick leave, maternity leave, and protection against unfair dismissal. They are also covered by laws regarding working hours and health and safety. The second point is job security. Employees generally have greater job security and protection against arbitrary dismissal. Employment laws typically require a valid reason and proper procedure for termination. Number three, anti-discrimination laws. Employees are protected by anti-discrimination laws that prevent unfair treatment based on characteristics such as race, gender, disability, and religion. So I've looked at employees. Now let's distinguish from independent contractors. Under independent contractors, our first point is limited rights. Independent contractors do not have the same statutory rights and protections as employees. They do not receive benefits like paid leave or protection against unfair dismissal. Under independent contractors, there are contractual terms. Their rights are governed by the terms of their contract with the client rather than employment law. This means that protections can vary and are typically less comprehensive. So this is a distinction between employees and independent contractors. Another difference is contractual and operational flexibility. So for employees, there are what is called long-term relationship. Employment contracts are often long-term and provide job security. Let's look at fixed terms. Employees may leave fixed working hours, roles, and responsibilities. On the other hand, independent contractors. Number one, short-term or project-based. Independent contractors are short-term or project-based. Here, contracts are often for specific projects or time periods, offering flexibility for both parties. Under independent contractors, There are also flexible terms. Flexible terms whereby contractors can negotiate the terms of their agreement, including deadlines and deliverables, and may also work with multiple clients. So this point is under contractual and operation flexibility. Let's move to our other point, which is liability and risk. Under liability and risk, employees have vicarious liability. Employees have vicarious liability. This means that employers are generally liable for the actions of their employees conducted within the scope of their employment. This means that if an employee causes harm or damages while performing their job, the employer may be held responsible. For employees, we also have insurance. Employers often have insurance to cover risks related to employees, including workers' compensations for job-related injuries. We have looked at employees. Now let's distinguish with independent contractors. Under independent contractors, we have personal liability. Independent contractors have personal liability. This means that contractors are usually liable for their own actions and errors and may need their own professional indemnity insurance. Under independent contractors, we also have risk management. Risk management, meaning contractors manage their own businesses. They have their own risks and often have to ensure their work complies with relevant standards and obligations. Am I clear? Hello?
Yes.
Okay. So I've looked at liability and risk. Now let's move to compliance and regulatory consideration. So under compliance and regulatory consideration, employees have employment regulations, meaning employers must comply with various employment laws and regulations, including health and safety standards, anti-discrimination laws, and wage regulations. We also have record keeping. Employees under record keeping, employers are required to maintain records related to employment, such as hours worked, wages paid, and tax withholding. So on the other hand, independent contractors, there's contractual compliance, meaning that contractors must ensure compliance with the terms of their contracts and any relevant regulations for their specific fields. Under independent contractors, we also have less regulation. This means that generally there are fewer regulatory requirements for contractors compared to employees, but they must still adhere to industry standards and legal requirements for their service. Let's go to our other point, which is dispute resolution and termination. Under employees, there is what we call employment tribunals. This means that employees have access to legal mechanisms to challenge their unfair dismissal, discrimination, or other employment-related disputes. Under employees, we also have what we call notice period. Employment contracts usually include a notice period for termination, providing some job security. On the other hand, independent contractors, there is what we call contractual disputes. These are disputes which are resolved based on contract terms and may require mediation or legal action if issues arise. Under independent contractors, we also have what we call termination. Contractors can often be terminated with less notice or explanation depending on the contract terms. Let's go to our other point. Okay. We're also going to look at lease agreements. Lease agreements. So, the purpose of the lease agreement is to regulate the rental or property, either commercial or residential. Its key element is the key element of a lease agreement is rental amount, maintenance responsibility, and conditions for terminating the lease. For example, a commercial lease agreement for office space. We'll also look at partnership agreements. The purpose for a partnership agreement, it defines the terms of a business partnership, including the roles and contributions of each partner. The key elements of a partnership agreement is the contribution of assets, profits, sharing agreements, management responsibility, and dissolution procedures. An example of a partnership agreement is an agreement between two entrepreneurs starting a joint venture. We have looked at partnership agreements. Now let's move to non-disclosure agreements. Non-disclosure agreements. The purpose for a non-disclosure agreement is to protect confidential information from being shared with unauthorized third parties. Its key element is to define of confidential information, obligations of the parties, and the duration of confidentiality. An example of non-disclosure agreements is between a company and a potential investor to protect business secrets. We have looked at non-disclosure agreements. Let's move to the nature of agency contracts. The nature of agency contracts. Let's start by defining what an agency contract is. An agency contract is an agreement where one party, the agent, is authorized to act on behalf of another party, which is the principal in dealings with third parties. The agent's actions within the scope of their authority bind the principal to the agreements made with third parties. So I've defined what an agency contract is. Now let's look at the formation or the types of agency. Number one, we have express agreements. An agency can be formed by express agreement. This is clearly articulated terms where the principal explicitly appoints the agent. Authority is explicitly granted by the principal to the agent, either orally or in written. An example of an express agreement, agency under express agreement, is a company formally appointing a sales representative to negotiate contracts, or a person authorizing an attorney to represent them in a legal matter. So we have looked at express agreement. Now let's move to implied agency or implied agreement. Implied agency arises from the conduct or situation of the parties rather than a formal agreement. The characteristics is the agent's authority is not implicitly stated but is inferred from the actions or the nature of the relationship. An example of implied agency is when an employee acting on behalf of their employer in a manner consistent with their job duties, even if it isn't a written contract specifying this authority. So these are the characteristics and examples of an implied agency. Now let's move to agency by estoppel. Agency by estoppel. This arises when a principal's actions or representations lead a third party to reasonably believe that an agency relationship exists, even if no formal agency has been created. The characteristics of agency by estoppel. The principle is estopped. The principle is estopped, meaning the principle has been prevented from denying the agency relationship when it would be unjust to do so. An example of agency by estoppel is a company which allows an individual to act as their representative and make decisions, and the company later cannot deny the agency if the individual enters into a contract that binds that company. We have looked at implied agency, agency by estoppel. Now, let us move to agency by ratification or ratified agency. Agency by ratification occurs when an agent acts without authority, but the principal later approves or ratifies the agent's actions, thereby making the agency relationship reactively valid. The characteristics of ratified agency is the principal accepts the agent's actions and assumes responsibility for them. An example, let me give you an example of ratified agency. An agent making a contract without authorization, and the principal later agrees to the contract, thereby ratifying the agency action. Now, let's look at general agency. These are the types of agents. Let's look at a general agent. A general agent grants the agent broad authority to act on behalf of the principal in a wide range of matters. Let's look at its characteristics. The agent has significant freedom in decision making and handling various tasks. An example of this type of agent is a business manager who oversees the day-to-day operations and makes decisions on behalf of the business owner. Let's look at an apparent or ostensible agent. An apparent or ostensible agent. This occurs when a third party reasonably believes an individual is an agent based on the principles, representations, or conduct, even if no formal agency relationship exists or existed. One of the characteristics is the principal is bound by the actions of the agent in dealings with third parties, even if the agent was not authorized. An example of this type of agency is a business manager who appears to have the authority to make contracts or on behalf of a company, leading third parties to believe in their authority. So we have looked at the type of agency formation. Now let's move to termination. Termination of agency relationship. Number one, agency will be terminated by mutual agreement, meaning that both the principal and the agent agree to end the relationship. Both the principal and agent, they agree to end the agency relationship. Our second point here is completion of purpose. Agency may be terminated under completion of purpose. This means that the agency will end when the specific task or objective for which the agency was created is accomplished. Under termination of agency, agency may be terminated by revocation. This means that the principal can revoke the agent's authority, though this might have legal implications depending on the agreement and the circumstances. Our fourth point here is resignation. Agency will be terminated through resignation. This means that the agent decides to terminate the relationship, often providing notice as per the agreement. Our fifth point here will look at the operation of the law. Agency will be terminated under operation of the law. This means that the agency may end due to unforeseen events such as the death or bankruptcy of either party. The death or bankruptcy of either party. Agency will also be terminated under automatic termination. Under automatic termination, this can occur due to death, insanity, or bankruptcy of the either party. So these are the ways in which agency may be terminated. Now let's look at the duties of the principal and the agent. The duties of the principal and the agent. We'll start by looking at the duties of the principal, which is number one, compensation. The principal has a duty to compensate. Under compensation, the obligation is to pay the agent as agreed upon in the contract. The obligation is to pay the agent as agreed upon the contract. The principal has a duty to reimburse. The principal has a duty to reimbursement. This means that the principal should cover reasonable expenses incurred by the agent in the course of their duties. Our other point here is indemnification. The principal has the duty to indemnify. This means that the principal should protect the agent from liability arising from actions taken within the scope of their authority. Our fourth point is the principal has the duty to support the agent. The principal has the duty to support the agent. This clearly tells us that the principal must provide the agent with the necessary support and information to perform their duties. These are the duties of the principal towards the agent. Now let's look at the duties of an agent. The duties of an agent. Number one, an agent has the duty of loyalty. An agent has a duty of loyalty. This means that an agent has a duty to act in the best interest of the principal and avoid conflicts of interest. Number 2, the agent has the duty of obedience. An agent has the duty of obedience. This must follow lawful and reasonable instructions provided by their principal. The agent must follow lawful and reasonable instructions provided by their principal. An agent also has a duty of care. An agent should have a duty of care. An agent is expected to perform their duties with a reasonable degree of skill and diligence. An agent is expected to perform their duties with a reasonable degree of skill and diligence. Our other point we're going to talk about is disclosure. An agent has the duty of disclosure. This is required to inform the principal of all relevant facts and information pertaining to the agency. An agency also has a duty to follow instructions. An agent has a duty to follow instructions given by the principal. Agents must act accordingly to the principal's instructions, provided they are lawful. Our other point we're going to talk about is duty to account. An agent has a duty to account. This means that agents must account for any money or property received on behalf of the principal. So we have talked about the duties of the principal and the duties of an agent. Let's move to benefits and drawbacks of using standard form contracts. The benefits and drawbacks of using standard form contracts. We're going to start by looking at the benefits. The benefits of using standard form contract. Number 1, efficiency. Standard form contracts simply the contract's drafting process, saving time and reducing administrative burdens. Efficiency. Standard form contracts simplify the contract drafting process, saving time and reducing administrative burdens. So these are the benefits of standard form contracts. Number 2, consistency. Under consistency, the benefit is to ensure uniformity in terms across similar transactions, which can help in maintaining consistent business practices. Under consistency, it ensures uniformity in terms across similar transactions, which can help in maintaining consistent business practices. So, another benefit is the cost effectiveness. Another benefit is cost effectiveness. Under cost effectiveness, the benefit is to reduce legal costs by using pre-drafted templates rather than custom drafting every contract. Rather than drafting every time you're drafting contracts. So, cost effectiveness reduces legal costs by using pre-drafted templates. Now we go to another point, which is clarity. One of the benefits is another benefit is clarity. Clarity provides clear and established terms that can minimize misunderstandings and disputes. So I've looked at the benefits of using standard form contracts. Now let's look at the drawbacks. The drawbacks of using standard form contracts. The drawbacks of using standard form contracts. Number 1, lack of flexibility. The lack of flexibility. This means that standard contracts may not address specific needs or concerns of all parties involved, potentially leading to issues if the contract terms are not well suited to particular circumstances. Number 2, overlooked terms. The drawbacks, one of the drawbacks is overlooked terms. Parties may not thoroughly review standard terms, leading to missed clauses or misunderstandings about their obligations. Number 3, unfair terms. One of the drawbacks is unfair terms. This means that if the standard form is biased towards one party, it may create an imbalance that is unfair to the other party. Number 4, negotiation limitations. Negotiation limitation is one of the drawbacks of using standard form contracts. Under negotiation limitations, standard contracts might limit the ability to negotiate terms, which can be a disadvantage if specific conditions or considerations are important to one party. So, when understanding the types of business contracts, the dynamics of agency agreements, and the advantages and disadvantages of standard form contracts is crucial for managing business relationships and agreements effectively. Each type of contract serves a distinctive purpose, and the nature of agency agreements involves specific duties and obligations that both principals and agents must uphold. Meanwhile, while standard form contracts other efficiency and consistency, they also present challenges related to flexibility and fairness. Let us move to establishing the relationships of employer and employee and the concept of self-employment. Establishing the relationship of employer and employee and the concept of self-employment. So, employer and employee relationship. Employer and employee relationship. The relationship between employer and employee is primarily defined by employment contracts, which can be either written or oral. The key legal rules that establish this relationship includes: number 1, control test; 2, integrated test; 3, mutual obligation. Under control test, the employer has significant control over how, when, and where the work is done. Number 2, integration test. The employee's work is integral to the employer's business. Number 3, mutual obligations. There are mutual obligations of personal service from the employee and payment for that service from the employer. Let's look at self-employment. Let's look at self-employment. Self-employment. So, on self-employment is characterized by the individual running their own business, where they are responsible for their own taxes, insurance, and business expenses. They have more control over their work and are not subject to the same degree of oversight as employees. This distinction affects, number 1, vicarious liability. Vicarious liability. Under vicarious liability, employers are generally liable for wrongful acts committed by employees during their employment. Under vicarious liability, employers are generally liable for wrongful acts committed by employees during their employment. This does not extend to self-employed individuals who are responsible for their own actions. Under self-employment, we also have statutory employment rights. Statutory employment rights. This means that employees have various statutory rights. For example, sick leave and maternity leave, which do not typically affect to self-employed individuals. Let's now move to the specific nature of the contract of employment. The special nature of the contract of employment. Number one, we have employment contracts. Let's look at employment contracts. An employment contract is distinctive because it is subject to significant legislative interference to protect worker rights. An employment contract is distinctive because it is subject to significant legislative interference to protect worker rights. So now let's look at the key features of employment contracts. Number one, legislative protections. Legislative protections. Laws regulate minimum wages, working hours, health and safety, and other employment conditions. Point number two, unfair contract terms. Legislation often prevents unfair terms in contracts that might disadvantage employees. For example, excessively restrictive non-complete clause. So, the purpose of legislative interference. The purpose of legislative interference is to balance power between employers and employees, ensuring fair treatment and basic protection, thus countering potential exploitation in a power imbalanced relationship. Let's look at the health and safety at work. The health and safety at work. The requirement is that employers are required by the law to ensure a safe working environment. The employers are required by the law to make sure that there is a safe working environment. These key regulations include number one, risk assessment. Number one, risk assessment. Employers must carry out risk assessment and implement measures to mitigate identified risks. The second point is training and equipment. The first one we looked at is risk assessment. Now it's training and equipment. Provision of appropriate training and equipment to employees. Employers are required to make provision of appropriate training and equipment to employees. Let's look at the sanctions and remedies. The sanctions and remedies. So we have criminal sanctions and civil sanctions. We have criminal sanctions and civil remedies. Under criminal sanctions, employers failing to meet health and safety requirements can face criminal prosecution, fines, or imprisonment. Under criminal sanctions, employers failing to meet health and safety requirements can face criminal prosecution, fines, or imprisonment. Let's look at civil remedies. We've talked of criminal sanctions. Now let's look at civil remedies. Under civil remedies, employees injured or harmed due to safety breaches may claim compensation through civil courts. Employees injured or harmed due to safety breaches may claim compensation through civil courts. Let's look at discrimination and protection. Discrimination and protection. Under discrimination or protection, we have legislative framework. Legislative framework. Employment laws prohibit discrimination based on number one. Employment laws prohibit discrimination based on number one, sex. Laws such as the Equality Act of 2010, which is an act of Parliament of the United Kingdom, prohibits discrimination based on gender, including pay disparity. Number two, we have race. Under race, there is protection against racial discrimination in hiring, promotion, and working conditions. Under discrimination, we have race, which protects against racial discrimination in hiring, promotion, and working conditions. Under discrimination protection, we also have disability. On disability, employers must make reasonable adjustments for disabled employees. Employers must make reasonable adjustment for disabled employees. Under discrimination protection, we also have religion and belief. We also have religion and belief. So this entails us that there is prohibition of discrimination based on religious beliefs or lack therefore. Under religion and belief, we have prohibition of discrimination based on religious beliefs or lack thereof. So now the enforcement of this discrimination protection. Individuals who believe they have been discriminated against their working rights can seek remedies through employment tribunals or civil courts. Civil courts, they can also seek through the Industrial Relations Court, which deals with labor laws, with commercial laws. Let's move to termination of the contract of employment. Termination of the contract of employment. So, let's define what termination of contract of employment is. The termination of the contract of employment is the end of an employment contract, and it can occur through resignation, dismissal, or redundancy. It can occur through resignation, dismissal, or redundancy. So the key aspects include number one, unfair dismissal. Number one, unfair dismissal. Employees with qualifying service are protected from unfair dismissal, which can be challenged at an employment tribunal. Employees with qualifying service are protected from unfair dismissal, which can be challenged at an employment tribunal. Number two, we have redundancy. We have redundancy. This means that employees dismissed due to redundancy are entitled to redundancy pay and other statutory protections, provided certain conditions are met. Provided that the certain conditions are met. Under termination of contract, we also talk about legislative protection. Legislative protection. Unfair dismissal. Under legislative protection, legislation requires that dismissals be for a fair reason. Dismissals be for a fair reason. For example, conduct, capability, and the proper procedures. For example, conduct, capability, and that proper procedures are followed. So under legislative protection, we have unfair dismissal, where legislation requires that dismissal be for a fair reason. For example, conduct, capability, and that proper procedures are followed. Under legislative protection, we also have redundancy. This means that redundancy laws require employers to follow fair selection criteria and consultation processes. Redundancy laws require employers to follow fair selection criteria and consultation processes. These areas of employment law are crucial for maintaining fair and safe working environments and ensuring that employees' rights are protected while balancing the needs and the responsibilities of employers. These areas of employment laws are crucial for maintaining fair and safe working environments and ensuring that employees' rights are protected while balancing the needs and responsibilities of employers. So, for today, we end here. For today, we end here. Hello? Hello?
Hello.
Yes, I'm saying, can you hear me?
Yes, we do.
Okay, so for today, we end here. Part 4, I will communicate when we're going to have it. The one we just had is part 3. Part 4, I'll communicate when we're going to have it. Before I leave, do you have any questions? Hello? Hello?
Hello.
Do you have any questions? Oh, for the notes, I've put just wait a minute. For the notes, you can just get my number there. Are you able to see the number?
Yes.
Yes, just message me on WhatsApp. I'll be able to share the notes with you.
Thank you.
Okay, you're most welcome. So for today, let's end here. I'll communicate when we're going to have part 4.
Thank you very much.
Okay, have a good evening, everyone. If you have any challenges, feel free to contact me. I'll be able to assist you.
Hello.
Yes, hello.
Good evening.
Evening.
Thank you. Madam, is it not possible for you just to send those notes on WhatsApp group?
Okay, No problem. I'll just share with them on the group.
Because we have a special WhatsApp group for 1.2.
The thing is, you've created one
Yes.
for just commercial law.
No, for I think semester 2.
Okay, I'll be able to share with you the notes. I didn't want to share them on that group that we have because there are so many people that are taking different courses. So if you are
Exactly.
saying if you are saying you have created a group for is it second year, first year?
First year, semester 2.
Yes, no problem. I will be sharing the notes there with you.
Okay, fine. Then I think the admin have to add you on that group.
Okay, sure. You can just add me to the group. I will share the notes with you.
Okay, fine.
Okay. Thank you very much, everyone. Have a good evening.
Thanks, you too.
Okay.